Let me introduce now our presenter today, Niels Versman, who is a senior lawyer with our Australian firm McPherson Kelly, based down there in Victoria. He's talking today on trading in the Pacific when local and international brands collide. I'm going to give you a few little bits and pieces about Niels. He's passionate about what he does, and he's a very, very highly respected cross-border and international IP lawyer. He has an unaverted passion for the area, enthusiastically maneuvering himself through technical complexities, he assures me. He works across all industries and in particular has a wide range of experience with manufacturing businesses, with everything from food, manufacturing to homewares. He has significant experience assisting not only large multinationals and commercial enterprises, but also not-for-profits with their intellectual property concerns, ensuring that they can focus on the communities that they seek to help. Niels, thank you for giving up your time and coming to play with us today, and we're looking forward to hearing what you've got to say.
Well, thank you, John. My only disappointment is that I'm not able to present this webinar from a location in the Pacific. The budget didn't quite stretch to flying me out on location somewhere so that I could sit somewhere with a real beach in the background and real palm trees. But you know, I've got a little bit too much skin on the forehead to want the glare coming off the head anyway, so that's probably not the best for me. Thank you very much for joining us today. I'm really pleased to see so many people online. John mentioned I'm from McPherson Kelly, which is affiliated with the Pacific Legal Network. So I'm about to switch from PLN branding to our branding. This is what I'll be talking about today. We want to acknowledge the traditional custodians of the land on which we live and work. We recognise their strength and pay our respect to elders, past, present, and emerging. And I know probably each of you will have different communities in your local area. This is going not just Australia-wide, but international. What is a trademark? And I'm going to throw these up very quickly, these definitions. We'll circulate the slides and you can look at this in more detail. But really, this is just a way of saying that a trademark can be a lot of different things. And most countries, and I've got here definitions from Australia, New Zealand. I had a look in Fiji. Obviously, there are a lot of countries in the Pacific and with lots of different bits of legislation, but there is a commonality to this. A trademark is a sign that is used to distinguish the origin of goods or services from those of other traders, to say this is the trader that produces these goods or services as opposed to the other traders out there. And a trademark is generally defined as being, it's a sign that does these things, and a sign can be a plethora of things. And I'm not going to look at this list here, but the list is extensive and it is intended to be inclusive, so it can include these things, but it can be other things. I'm going to look at some examples to just give you an idea of what it can be. And it can be anything from names. You know, we've got really well-known names, Apple and Amazon. We've got really well-known logos, shapes. So the Coca-Cola bottle that you see there, that is a registered shape trademark. Shapes are very common with packaging. Everything from beverages to perfume and various types of food packaging. Generally less so the goods themselves. They're less shapes. They're protected in other ways as registered designs, but the packaging is often a branding element of those products. Colors, that of course is the 7-Eleven logo down the bottom, their colors. There are some movement trademarks, and the numbers in brackets are how many of these registrations we have in Australia. And being the sort of largest IP ecosystem in the Pacific, it's the place where we're most likely to find these things. If anyone's seen Toyota commercials in Australia in the last 30 years, there's usually somebody jumping up in the background at the end with the "Oh, what a feeling Toyota" thing, and those people jumping, that leap, that's a registered trademark. We have sound trademarks. The Yahoo Yodel is probably a good, well-known international one. For people in Australia, some wonderful examples are compare the market, simples, that's what the meerkats say, and roof seal, the seal going roof roof, that's also a registered sound trademark in Australia. And then we have some scent trademarks. There are only 2 of these. 2 scent trademarks in Australia, which is not a lot. And so down the bottom here we have some peanut butter jars. This is an aspect of sort of color trademarks, logos. There was a big fight in Australia, sort of 3 years ago, 2-3 years ago, between Kraft and Bega over peanut butter. The fight wasn't about the name Kraft, it was about the yellow lid and that sort of blue stylized peanut on a yellow label. That was a trademark fight over those things. They're aspects of packaging. So those sort of things can be trademarks. So we want to look at from the trade perspective. The brief is when local brands and foreign brands collide. And we've got generally two considerations, 2 desires here. We've got the local brands, the local businesses that want to protect their brands and their products against imports, or foreign businesses that set up factories locally, but basically foreign brands coming in. And similarly, we've got foreign brands that come in and they want to avoid stepping on people's toes. And so I want to look at some of those aspects of what is involved and what these both sides of the equation can do to avoid stepping on the toes of others. So some key issues for local businesses, and this goes not just in the Pacific, but really anywhere. One of the key things is registration is generally the best way to protect your brands, your trademarks against misuse. It gives you the strongest rights to be able to action them. In some countries that don't have strong usage-based rights, it's really the only way. In other countries, it's definitely the most effective way. A lot of the time, it means you don't have to demonstrate a reputation in trademark. So if push comes to shove, it's the biggest weapon you can wield. So it's really great to have this. But there's also another aspect of the next part I want to talk about, and this is making yourself findable. And this is really something for the local brands in protecting themselves against the foreign brands. And part of that is often you'll have the people entering the market looking, what are the existing trademarks in the market, because we want to avoid them. We don't want the confusion. We don't want the lawsuit. We don't want the threats or the bad publicity that comes with entering a market and being seen to be trampling on a beloved local brand. So there's a few things there that you can do. One is the registration, particularly in those jurisdictions that have a publicly available trademark register, and registers are more easily searchable in some countries. Some countries you can just do the search, like Australia and New Zealand. Other countries you've got to engage local agents. But part of that is staking your claim so that if somebody's doing a trademark search, they can see that you've got a registration. It's the aspect of trademark registration that benefits you that you never get to see, because you never see the people that have done a search and have changed their intended branding because of what they've seen. Have a website that shows your trademarks. People are going to search, and particularly in there are some jurisdictions, and there are some jurisdictions without a registration system, and they're sort of in the last dot point there. It's making sure that if somebody's doing that due diligence, they can actually find you. And the elements of that are making sure you've got a website with your country code. I mean, if you've got a .com domain name and your website doesn't say which country you're in, how is anybody going to find you if they're legitimately looking for your business to see what are your brands, what are your trademarks? You need to be searchable. And so ideally, if somebody's searching by the product category and the country, they need to be able to find you. And part of that is having the country code on there, but also having something on your website that says where you are. And I know that sounds basic, but I have looked at, I've come across businesses, do clearance searches, and I see businesses with websites, and I look at it and go, I don't even know which country this business is in. They're a .com. They don't have an email address. They don't have a phone number. They don't have a physical address. They usually just have a contact me form on the website, but they've got nothing else. If that's you and you want people to be able to see that you've got a brand and want to avoid that brand, they're not going to avoid you if all you've got is non-specific details as to where you are and what your brand is. If you've got pictures of your product on the website, have another picture with the packaging so people can see what does it look like, what colors do you use. People do this due diligence. I get engaged by clients to do this, and you need to make yourself be found. Otherwise, you're doing yourself a disservice and your brand a disservice. For the foreign businesses, definitely do searches. I think that's really important. It's part of being a good and prudent corporate citizen. Australian courts have recognised that honest trading and being an honest trader and entering a market or adopting a new brand involves doing due diligence as to whether that brand is available. And I think that principle applies anywhere. It's just that we've had more litigation of those things in Australia, and so therefore we have more case law on it. But I think those principles are there, that in a world where searches can be done and this information is often at your fingertips, is you should be doing those searches. And when you're looking at specific countries, I mean, some countries like use Google, and you go to google.com.au and you can specify just searching in Australia, but that's not available everywhere. Even New Zealand, you can't go to google.co.nz and say, I just want to search in New Zealand. So those searches, this is where the country code comes in, and your domain name, having that. If you're looking in New Zealand, you can search in google.co.nz. And wherever you are, you want to make sure that you're found in that sort of case. You can also engage people to literally have a look at what is being sold. And in those countries where you're not necessarily having the e-commerce structure, you should be as part of that due diligence is literally saying to your local agent when they get them to do searches, if this is something that you're going to sell on a supermarket, what is on the supermarket? Is this a concern with what is on the shelf? And what is around? Use that local knowledge, tap into your agent's local knowledge and say, is this a milk brand that is around? Is this a car parts brand? And whether they pop into their local auto supply store or their local supermarket, that should be part of it, particularly in those countries without a trademark registration system. That's quite important. There are some, even those countries with a registration system, there are some peculiarities in the Pacific arising from some of these jurisdictions being very small, and some of the colonial heritage as well that still permeates through the Pacific. So we've got some odd situations that's really important to be aware of. So for example, Norfolk Island doesn't have its own trademark registration system. The Australian trademarks apply to Norfolk Island and cover Norfolk Island. Same with a bunch of French territories. New Caledonia, of course, has been in the news a lot in relation to the French connection in recent months in very unfortunate ways. But they have the French registration system, and it is the same trademarks. If you register in France, you protect yourself in New Caledonia, French Polynesia, North Mariana Islands, and the US has some territories there as well in the American Samoa, and Guam. There are also a few jurisdictions that have an unusual way in effectively piggybacking on foreign registration. That's Kiribati, Solomons, and Tuvalu, where you've got to have a UK trademark registration, and then you get that re-registered in that local jurisdiction. Fiji has a sort of a different system in that you can apply directly for registration, or you can use this re-registration from the UK. When I was researching this, I'd previously done registrations in Fiji using lawyers in Fiji. I wasn't aware that re-registration from the UK was also available, but it is. So if you're wanting to go into those countries, you need to consider, is the brand available, particularly Kiribati, Solomons, Tuvalu. You also need to consider, is it available in the UK? Because you're going to need initially that UK registration to piggyback off to get local registration. So it complicates that vetting because you may need to search in the UK as well, or you may need to consider Australian trademarks, French trademarks, the very, very crowded US trademark database, and all of those sort of things. Now, I wanted to also have a look at some of these unusual types of trademarks. Things that are not necessarily considered, and these are things that whether you're a local brand or an importer, they're aspects that you should consider in your searching, but also might want to consider in your registrations. And this is what we refer to as trade dress. And these are things that can be incredibly powerful as far as recognizing, creating recognition of brands. And so we have on the left something that for all the people in Australia, I would be surprised if anyone here who's in Australia does not recognize what that thing is on the left. That is a Vegemite jar without the labeling. Without the branding, but that is a registered trademark of Bega, which now owns Vegemite. We've got on the right, we've got a Raffaello box. Again, it is the sort of thing that if you've got a local brand, a local product, and you are concerned that somebody is going to come in and maybe use something that looks similar to your product, and this is particularly where those sort of consumer goods, those supermarket consumer goods, where that's particularly important, where people quickly grab it. We're not talking about $500 items or $2,000 items where people pay attention. This is the cheap commodity groceries where people grab it when they see it in the supermarket. And your local brands, you should be looking at how you can protect that. Similarly, if you're coming from overseas, this is where it's important that you don't just look at the register, but that you have a look at the supermarket shelf. And where I've said that it's good for local brands to have their packaging on their website, because people look at this and consider this and how do we present our goods. And that's a really important bit. I've just got a couple more examples. On the left, of course, is a brand that's very, very well known in Australia. This is the Toilet Duck toilet cleaner, but something that is recognizable, and people recognize this product off the packaging. And on the right, I'd never heard of Oz Avo. It's in relation to avocados. I don't really like avocados, so it's not something that I identify, but it shows how products can be branded, not necessarily on a product itself, but the packaging, and how that can be something that you see that in the supermarket. And if you are someone who likes avocados, you may well say, oh yes, I recognize these avocados. This is what I should be buying. You recognize it off the packaging. A really important consideration, and this is something that becomes particularly important with these cross-border transactions. And so it's a big pitfall, because we all operate with everything we do. We operate based on assumptions that we have and preconceived ideas as to how things work, and therefore what we should do. But in the world of trademarks, we have two very different trademark systems. One is what we call first to use, or sometimes first to use or file. It is a system that gives very, very strong rights to users of trademarks, even if they're not registered. So that if you have used a trademark but not registered it, and then somebody else comes along after you, registers that trademark, your earlier use can displace their later registration. This is something that is in the Pacific, is the more common system. I've listed some countries there that use this system, as well as some countries in the brackets that are outside of the Pacific, just to give you an idea of which other jurisdictions use this system. It makes it particularly important when you're doing searches that you're looking for unregistered trademarks. Even if there is a registration system, if you're going into a first to use system, you need to do these searches. So if you've got if you're a business coming out of China or Indonesia or the EU, wanting to go to the Pacific, you've got to appreciate that this is part of their system, and you need to look at these usage rights, and you can't ignore them, and these searches need to cover them. But you shouldn't be complacent about these rights, because it can be expensive to enforce these rights. And depending on where you are, those rights can give you more or less of a leg up. In Australia, we have what's known as being able to get a trademark registered through prior use. If you can show you used your trademark first, you can have parallel registration, even if somebody else has come along in the meantime and registered their later trademark before you. But in the US, you need to challenge the other registration in court and get it revoked. So it's a much, much more expensive process. So you have these rights, but you don't want to be complacent about, oh, I've got these usage rights. They may be quite expensive to enforce, and that's quite hard for a smaller local brand to do that against a multinational that comes in. The other system is first to file. The only one that I was able to find in the Pacific that is first to file is Tonga. Apart from France, which is also first to file, and so New Caledonia, French Polynesia, and North Mariana Islands, by virtue of being the French system, are also first to file, but that has its own system. It's only Tonga, and their really registration rules supreme. So if you are a local brand that has been using its trademark, and you've got a multinational that comes in and they're used to registering their trademarks, they go, okay, fantastic, we'll register. Even though you were there first and you were using it first, you lose those rights. So in those countries, registration absolutely rules. Same in reverse. If you're a Pacific country, I mean, I've spoken about Pacific businesses being encroached on by multinational businesses, but the same works in reverse. If you're a Pacific business and you wanted to go overseas, you're in a first to use jurisdiction, like Samoa or Vanuatu or Fiji, and you wanted to export to China or to Indonesia or to the Philippines, you're suddenly entering into a system that is very different, and you need to register, because it certainly happens. Excuse me. It certainly happens that importers come in, and then other businesses, local businesses, register a similar trademark. Sorry, local businesses register a similar trademark, and then suddenly you as the foreign business can't use the trademark that you've been using because you weren't aware of the importance of registration and the registration trumping usage rights. Sometimes these jurisdictions do protect very famous brands. So China has a system where even though it's first to use, it will protect famous trademarks, but that's a pretty high bar. So if you've got usage of a famous trademark, that's great. Otherwise, you can be gazumped, and famously, Apple paid, I think, about 70 million US because somebody got the jump on them with the iPad trademark, and that's years ago. And they bought it off them. Other issues to ignore, not to ignore. When you're going and doing transactional things. Language. People speak different language, and some of these Pacific countries, you might have multiple languages. You go to PNG and you've got hundreds of languages. You need to consider these languages, and there are a few different things there. One is, should you be registering your trademark in a local language? That's particularly an issue where you've got different script. So that's something that we always talk about with our clients that go into places like China or Korea or Japan, where literally people can't read your trademark unless you go local script. But if it's something that is not just a completely made up word, but it is something that in Australia or an English speaking jurisdiction is a dictionary word, you've got to consider, is that the appropriate brand to use in a country where English is not the dominant language? And consider how you should translate that and how that should work, whether you've got the original language label on one side and the local label on another side, but you've got to consider that. How best you represent that, how best you brand it. That also comes into searching, of course. You've got to do your searches in the local language because you want to make sure if you've got a dictionary word in English as part of your trademark, that you're not stomping on somebody with the same with the translation of that word in the local language, because that may well then be too similar to be allowed to be registered and used. Particularly if the trademark is coming in English, because a lot of people are going to recognise that. I probably wouldn't worry about it too much if you're going into Samoa with a trademark that's an Albanian, but if you're going in there in English, you can probably expect that people will confuse it. Some of these countries, there are cultural issues that I think are really important. In New Zealand, we of course have a system that in the trademark system actually considers Maori culture and considers whether a trademark will offend Maori culture. And there's an advisory committee if it's flagged as being a potential Maori culture issue. It goes to the advisory committee, and that will then say whether that is the basis for a trademark that's going to offend or not. And you can be rejected in New Zealand because it's something that offends Maori culture. Even if that system doesn't exist in those countries, you do have the risk of offending, and there have been some examples that I was able to find. There was a US registration for Bula Kava in relation to some kava shops, and Fiji got very, very agitated about that because Bula is a common greeting in Fiji. Similar with a US registration for Aloha Poke. People in Hawaii got very annoyed that people were trying to monopolize that common greeting of aloha. And then in Australia we had Barobi the koala. Barobi was the mascot for the Commonwealth Games on the Gold Coast a few years back, but Barobi is a word for koala in the local Indigenous language. This was opposed unsuccessfully, the trademark registration, by the local Indigenous community on the basis that, including that it falsely implied authorization by the Indigenous community. While it wasn't a legal issue, you've got the prospect of really offending locals if you're seen to be appropriating those elements of the local culture, particularly as a foreign business. And wherever you go, and this is not unique to the Pacific, you've got to be aware of how what you do is perceived by locals, and how that may come across. And certainly talking to locals is a really good start. You can't just say, oh, that's a common word in that language, or we'll adopt a word in that language, and suddenly it's probably less of an issue in countries somewhere like Australia. We've got a lot of different Indigenous cultures, and therefore the number of people who might be offended is relatively small. But in some of these cultures, if you're appropriating something from the dominant local culture, this could kill your business. If you're perceived as being disrespectful to the local culture, this could really kill your business. And so you need to know your market, and that is a very important part of that. We are at the half-hour mark almost, and we now get to the very, very business side of things. This is us in our trademark and our IP team, and we work with John and his team, and we often we deal with trademark registrations in a range of countries, but John and the PLN team have a wonderful network in the Pacific, where generally most law firms don't have connections. So we're very fortunate to be able to lean on the Pacific Legal Network team in being able to utilize those connections in the Pacific, and being able to get that local knowledge and all those things that I've mentioned, whether it's searching for the multinational businesses, or assisting a local business to expand to another country in the Pacific. We've got those connections in that network and the expertise that we can call on to address those things that I have spoken about. Some of our team is in Melbourne. Mark heads up our Brisbane-based IP team. We've got a few more lawyers in that team. These are really just the senior people, but there are a bunch of additional people in Brisbane and in Melbourne that deal with IP and work with PLN in Sydney. Then I get to the real end, the redness searing orange.
Great, thanks so much, Nils. That was very interesting. If anyone has any questions, please send them through the chat and I can read them out for Nils to respond. I actually do have a question myself, Nils. In relation to
Fantastic.
the first two, yeah. In relation to the first to use system, what
Yes.
are there any particular factors that someone or a court would consider in terms of determining use? Like, is it the amount of usage? Is it the period, like the time period of usage? Is it where it's used, or is it just the fact that it's being used?
Well, where it's used means use in that jurisdiction.
Okay. Right.
So if you're wanting to say, and say we use Australia as an example, I use my trademark, you come along, Isabel, and then subsequently and register a very similar trademark. I then need to show that I have used my trademark before you and then have continued to use it. So not abandoned it and have continued to use it. And depends on what I'm trying to achieve. If I'm just trying to get registered in parallel, I just need to show prior and continuous use. Okay. If I'm trying to displace you, then I need to show that I'm the true owner and that I have not abandoned my trademark. Terminology is slightly different, but essentially it means you were first to use it in relation to particular goods and services, of course. And this is always something that trademarks consider. It's not just, and I kept talking about what is the trademark, but you've got to consider the type of use. And you know, there's no reason why you can't have the same trademark in relation to computer monitors and bananas, because they are very, very different industries, and there are plenty of those examples. So it's in relation to those sorts of goods or those sort of services or related goods or services. But you need to show that you were first to use. If it's prior use, then we have things like honest concurrent use in Australia. That does involve a volume of use, but you don't necessarily have to have been first. You just need to have operated in parallel, but generally just being there first and having continued.
Yeah, great, thank you. Any other questions from anyone?
So, but if you're talking about China and you're showing that it's a famous trademark that you were first to use, then of course it's all about the volume and the recognition.
Yeah,
and
okay.
You know, that it becomes hyper important.
Right. Okay. So it's just a case by case sort of thing.
Jurisdiction by jurisdiction, and there are big differences in the way the details work. Even though when you've got systems that are based on similar foundations or the same foundations, the way it works and what you can challenge registrations for or applications for can differ significantly. I've got a hand up from Faisal.
Quick question: the where you find there's been some offensive conduct in a trademark context, how often do you find the usual cease and desist letters to be successful? Do people usually pay attention to them, or is it a step worth taking, or is it a step that you have to take ordinarily?
Well, look, I think lawyers answer, it depends on the circumstances. So if you can find an infringer very early on, the sooner you can get to them with a cease and desist, the better. Because the less they have invested in that business and the brand and their goodwill, the more easily they will change their brand. You know, it's much less painful for them than if they've got a huge volume of stock there or lots of shops that are sign written and they've spent lots of money on advertising and they've got that brand recognition. You're much more willing to give up something that isn't worth that much. Then it comes really down to the credibility of the threat. And that depends on how similar is it. If it's very similar, then you can be much more confident of winning a case. And so therefore the credibility of the threat is much greater.
Niels, can you
hear me? And then you've got the financials. Yeah, sorry, Faisal, just a sec.
Oh, sorry.
And then really the quantum of the loss. You know, if the infringement has been extensive, then there's more at stake if you sue in the way of damages, and more likely that someone's going to sue. If this has only just started and it's a very small infringer, the chance of it being worth suing is much smaller. Sometimes then it's a matter of that cease and desist not being the lawyer's sledgehammer, but sometimes it's a matter of being very pragmatic and saying, look, we're in this for the long haul and we're playing a long game. So rather than saying you must rebrand within a week, saying, look, we'll give you 6 months to trade down your existing stock. So you don't have to destroy your stock. You don't have to junk it. You can just sell out your existing stock, and then the new stuff you bring in with a different name on it. And it's that commercial aspect of we're here for the long haul, and we want this market to work in the long term, and you make it much easier for the other party to comply with your demands. Sometimes that can be a really good way of doing it, and we certainly do that sometimes, where we say, well, if the other side's going to have to destroy hundreds of thousands of dollars worth of stock, then they're going to go to court to prevent that. But if we say, look, we'll give you 12 months to trade down, yeah, that is much more likely to be accepted. It's much less painful for the other side to comply, and much more likely that they'll do it. So you've got to consider whether that's a possibility. Faisal, I'm sorry, please ask your question.
Sorry. Oh, so can you hear me now?
Yes, I can.
Yeah. Thank you. Well, firstly, thank you for that presentation. It's very useful for someone like me because I'm just not very good with the trademark stuff. The one thing that you have cleared up this afternoon, I thought that Eskimoto's example with the guy jumping up, I thought that had been trademarked by David Warner. Every time he scored a century at the SCG and the MCG, when he jumps up.
I don't know whether Warner has done that, but certainly Toyota has been doing that for. It is a very, very long running thing.
No, I am
but
aware.
maybe that
did,
Warner has done this in relation to cricket merchandise and that sort of thing. And maybe he's got an endorsement for cricket bats where he does that sort of thing. But Toyota does have it in relation to motor cars.
Yeah, I'm aware because I did go to school in Sydney, and I'm aware of that ad. But David Warner,
and they still do it. They still do it.
Yeah, and David Warner, every time he scores a century, he sort of jumps up exactly like the Toyota ad guy does.
Yeah, and that's fine. That's fine for Warner to do it because he's not trying to do it to sell cars, and those sort of things can exist of similar trademarks in relation to very good different goods and services. So if Warner decides to register that as a trademark for a brand of cricket bats that he wants to endorse, or sports drink or yogurt or whatever, then that's a possibility.
Sorry, on a more serious question, there's one issue that we grapple with in Fiji, and that's got to do with service marks.
Yes.
How we don't have a category for service marks under the UK registration.
You still don't?
No, we don't. So how do we get around? Is there any categories that you know or you use to get around that?
I don't know. I did. My experience with getting a trademark registered in Fiji was probably 15, 20 years ago. I wasn't sure whether it was still the case. Sometimes it's looking at related. Sometimes there are goods in relation to it that are connected with that as well. And you just make do with the best that you can and say, well, the goods are similar to this, are related to the services. It is a challenge if you don't have that available. You've got to consider what else the business does, and sometimes those businesses that do services will have other things. You might be an educational provider and you've got textbooks and those sort of things that you provide. If you have you might be a I suppose even a lot of it'll be a challenge for a lot of professional services businesses. It's probably more likely where you're a supplier of goods and you also do services, and you go, well, the goods are the dominant part thing anyway. You supply cars, but you also do servicing of cars. That's a service, and you can't register that. There might be spare parts that you sell for the services that you provide, or accessories or consumables, and you register the trademark in relation to those. You're more likely then to be relying on your common law rights and your potentially statutory rights in relation to misleading, deceptive conduct. And so You know, you effectively, exactly, and so you're effectively operating a system without a registration system, and it's being able to make sure people find you and can see what you do and can see those trademarks and what they are, and can find your business, and that means having a website that is meaningful, not crammed of content, but at least says, this is who we are, this is what we do, these are the services we provide, and this is how you can contact us. It doesn't have to be interactive in the sense of allowing people to order things through your website, but even just that information page of saying, you know, we are an accounting firm, or we are an architectural bureau, we do these things, and this is how we brand ourselves, and allow yourself to be found that way, and make sure the word Fiji appears on the website, and you've got the relevant Fijian country code on your domain name, and those sort of things, so people can find you. But yeah, it's a peculiar challenge.
Yeah. All right then.
But also the other aspect is getting advice from Fijian trademark lawyers. You know, I talk to you about this from Australia, but there are businesses they in some cases it's placing ads in local newspapers to notify people of their claim regularly. This is something I saw recommended in relation to some of these countries without a registration system. I think the best place to go is to talk to some trademark lawyers in Fiji and say, what are the tricks? How do you recommend that you do this? You know this system, you live with the system, you advise clients in that jurisdiction, and that's where PLN comes in with the local knowledge. I mean, obviously you are in Fiji, you can talk to local lawyers for you, but for the clients who are not in the jurisdiction, it's getting that local expertise and saying, hey, how can we do this? What do you recommend? What's best practice?
Yeah, we normally go under class 39 for service marks, but increasingly we're finding it's getting rejected.
Yep. So is it no service marks at all, or is it just certain classes that you can't register?
No service marks at all. But as I said, like you've been explaining, we're getting away with it on the various categories, classes. So we have been getting away with it under class 39, which deals with stationery marks and all these, paper clips and all that. And yeah.
So, okay, so Fiji doesn't use the international NICE classifications then, because class 39 in our case is in most countries is something quite different. That's a service service class.
Yeah. All right. Thanks, Neil.
For transport and things like that. No, you're welcome.
Okay, great. Cheers.
And that was a cameo performance from Faisal Hanif from Suva. Nice to see you, Faisal, who one of the head partners at the PLN office there in Suva. Obviously with some local challenges in the IP area, and great to have you on board.
Thank you. No, glad to have Niels here.
And look, sometimes, sometimes there is just no clear answer to something. There's no easy way around it.
In Fiji, it depends on what time you lodge, whether it's like in the morning when everybody's more diligent, or after lunch, and who you draw at the counter.
Who you draw, and this is something that I was just chatting with a trademark lawyer in the US yesterday, somebody who I deal with regularly there, and we were lamenting how much it is the luck of the draw of which examiner you get and what view they take. And you look at other trademarks and go, yeah, this type of trademark is not a problem, and you get an examiner who takes a different view, and that's the difficulty when you deal with humans interpreting laws. Everyone has their own opinion, and that's why you get appeal cases that go, 3-4 majority sort of situations. You go, yeah, 4 of them went this way, but three thought it was different. It gets tricky sometimes for these grey areas.
Thank you so much, Niels. And if there are no other questions, I think that just concludes the webinar for today. I want to give a special thanks to Niels for taking time to present to us. I think the presentation highlighted just how diverse and nuanced this area of law is in the Pacific. And hopefully everyone will leave learning, having learned something new. So thank you, Niels.
No,
and if you
you're
have any
very welcome.
questions, Ari has put Niels' email into the chat. So feel free to reach out to Niels directly or the PLN team if you have any questions.